on his own. I believe
So
my
Mr.
office had been this matter before.
Yeah, Mr.
but-
Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Buckle up, guys. Today we are going to witness the opening of a courtroom saga where Mr. Valentine, a full-blown sovereign citizen, boldly refuses legal counsel. The judge tries reason, offering a seasoned public defender, but Valentine's distrust of the system sets the tone for a bizarre ride ahead. This isn't just a traffic case, it's about to become a legal circus, and we're here for every second of it.
Is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about 30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up, I gave the clerk a letter, I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights.
All right, guys, now the judge steps up with one of the best analogies we've heard in court, comparing Valentine's self-representation to flying a jet solo with no training. Meanwhile, the prosecutor digs into his past failures to appear and pushes for high bail. It's a suspenseful standoff between courtroom logic and sovereign confidence, and the stakes are rising with every sentence.
Vehicular assault or homicide, given the history, while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then You have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that?
No, it's just free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated?
Brace yourself, because this is where the sovereign script hits full throttle. Valentine declares he's not a person, challenges the jurisdiction, and throws around pseudo-legal gibberish like rule nisi. The judge calmly slaps down the nonsense with legal precision. It's a textbook example of how fantasy law collides with the real world and loses.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
You can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that. So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed seri juris.
All right, that's up to you.
All right, folks, Valentine tries to flip the script by grilling the judge on her constitutional oath and challenging the definition of a person. What he doesn't expect is for the judge to handle him with calm authority, dismissing his semantic traps with grounded legal reality. This one's less of a legal argument and more of a sovereign identity crisis.
Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor. wishes to proceed without counsel.
Okay.
First of all,
Yeah,
I'd
hold on,
like to-
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
All right, folks, Valentine tries to flip the script by grilling the judge on her constitutional oath and challenging the definition of a person. What he doesn't expect is for the judge to handle him with calm authority, dismissing his semantic traps with grounded legal reality. This one's less of a legal argument and more of a sovereign identity crisis.
That status, otherwise we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you is why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
Here comes the irony. Valentine rails against government authority, but now wants government funding for a private investigator. He lists a flood of motions, claiming misconduct and denial of access, yet fails to follow basic procedures. It's peak sovereign behavior, rejecting the system while demanding its benefits. You can't make this stuff up.
There are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home, I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay.
Your
Well, this
Honor.
is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should
Yeah, I objected to his denial of those motions as well, because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th, and that was October 21st. I have a request to release you and your request, I'll go back, let me get back to your court to dismiss these charges, motion to release you, and that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which is probably the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact? Or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery.
Yes.
Okay. All right.
Yes.
All right. All right. Get it.
That's
Thanks.
the state's understanding as well, Your Honor.
All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward and the docket and your pleading. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of